I'd like to welcome everybody to the Wednesday, April 2nd, 2014 training and workshop meeting of the Raymond Planning Board. Because it's a workshop, we don't have to worry about a quorum, we don't have to worry about roll call. We're basically just going to discuss business, go through training, have our discussions, and hopefully adjourn and go home. We'll consider this a call to order. The training for the workshop is conducted by Town Attorney Shanna Cook Mueller. And at this time, I'd like to turn the docket over to Shanna and have her train us.
Okay, well, thanks. So I heard while I was talking with Greg before that that Danielle was trying to explain our firm and how we work with you all. I know Mary Costigan's been helping you out, assisting you through some applications. And my role as the town attorney is to make sure that everything that our firm does for your town happens the way it should. And so one thing that's come up over the last few years as I've been in this role is, you know, periodically I encourage Dawn and others to have me or someone else from my firm come and train municipal officials as there's turnover on planning boards and zoning boards and the Board of Selectmen, so that you know what's up to date about the law in general, and so that you can better serve your town in the role that you've taken on, and have a chance to ask questions that may have come up in your experience so far as a planning board member. So I want this to be a conversation, and so this can be as useful as possible for you all. But I thought I'd start out by asking how many of you have served multiple terms on the planning board, or what kind of experience you have on the board.
Well, I was on it from 2000 to 2002 or 3, and then I've been on it again from, I don't know, 2009, 2010, something like that to current.
Okay,
so,
great.
Yeah, 6 or 7 years, I guess, total.
Yep. Yeah.
I guess I have to call it my first term, even though there was a period of where I was not here, so one
Okay.
term.
Okay.
I'm in right now.
Yeah. Great.
One term.
Okay. Okay.
I think I'm on my second term, consecutive.
You've been on it forever.
I know I'm on the zoning board of appeals in my town, and I couldn't tell you when my term was up or when it started, so I kind of identify with
I'm
that.
gonna be confirmed and reconfirmed a second time. I think this is the 2 terms consecutive.
Okay. Yep.
This is my second term on the board.
Okay, so you got some people who have a longer period of experience, and some people who are relatively new, but I think it's good to have a variety on a board, so that, one thing I've seen in other communities is planning boards where it's the same group for 15, 20 years, and that's wonderful until they all decide they're done at the same time, and then there's no institutional memory. So I think this is a good mix. So some of the just to give you a preview of what I expect to talk about, and then so you can have it in your head where I'm probably going to go. One of the main things that whenever I'm giving a training to any municipal board that we talk about are conflicts of interest and bias, and in doing your role as a planning board member and making decisions for applicants. Just because we live in Maine, so it is hard to avoid having some kind of connection between a board member and an applicant at some point in time. So it's good to always have a refresher about what those rules are, so you know what to do if that circumstance arises. And then another area that I want to talk about are sort of the context of what your town attorney may deal with respect to the decisions you make. What I see is, when it comes to my firm, usually it's when there's an appeal from a decision of a planning board, and we're in Superior Court trying to defend your decision. So one thing I try to do in these trainings is give you some tools, or at least some ideas about what it is that's going to help us do our job if and when that ever happens to you all. which is never fun, but you don't have to worry about it when that happens because it's in our hands. But hopefully you can help me do my job if that ever happens by thinking about, findings of fact and the decision-making process that you go through. So we'll talk a little bit about that. And then the other thing that I always like to touch on is the Freedom of Access Act and the way that that places requirements on you all as planning board members. You may not feel like you have a whole lot of interaction with the Freedom of Access Act. Generally that's a law that makes it possible for any member of the public to come in and ask for any public document. And it makes all of your meetings required to be public and, open to the public. But there are other things that law now, you may not realize impose on you all as you're trying to do your job. So, any preference on where to begin? It sounds exciting, right? And I mean, it just interrupt me if, this is either something you already know and you want to move forward or, something you want to spend more time talking about. The first thing I want to touch on is the conflict of interest and bias. I took a look at your bylaws, which I know on your agenda you're going to talk a little bit about later, your bylaws. There are provisions in your bylaws relating to conflict of interest, but I also want to make sure there's a state statute that addresses conflicts of interest for municipal officials. And unfortunately, that's not the only source of requirements relating to conflicts of interest. There are also other rules that come up in case law that aren't identified in the statute. So I want to talk about both of those so that you just have the background. So the statute requires that it defines a conflict of interest in a certain way. It says that when an official is either an officer, director, partner, associate, stockholder of a private corporation, or business or other economic entity, is coming before the board, and you have a direct or indirect ownership of that entity of 10% or more, that is per se a conflict of interest, and you have to recuse yourself from that proceeding. So it's sometimes surprising to folks that it's only 10%. It's 10%. If you have 5% ownership in a business, you can still sit and and make a decision or participate in the process. I think there is a good argument for if you have less than 10%, but you have it, you may want to recuse yourself anyway. But the statute does define that 10% standard as per se conflict of interest, and it would be illegal for you to participate at all. So that's sort of the starting point. Then the other sort of general common law, which is case law rule, is that if you have any pecuniary interest in the result of an application, then you have a conflict of interest. And the definition of what pecuniary interest is not that clearly defined. But if you, one thing that we always recommend to our municipal officials is if you feel like there's a possibility someone could construe your relationship to an applicant as a conflict of interest, that you disclose that connection to your fellow board members before the discussion begins and the presentations begin, and you state on the record that you don't think, if this is true, that you don't think that your connection is going to affect your ability to be impartial in the decision-making process, but I'd like to leave it to my fellow board members to determine whether I should recuse myself or not, and then the chair puts it to a vote, and you'd vote whether or not that person should stay or should recuse themselves. And then it's on the record and it's dealt with, and then you can move on. Because I think practically speaking, people say, well, I mean, it's not going to make a difference to what I do, but I have this connection. I don't think I should recuse myself. And in some cases, in a lot of Maine communities that are smaller than the town of Raymond, you're never gonna get a quorum if, you know, you are too strict about these things, so.
I have a question about that.
Yeah, yeah.
I think you may have the same question. Go
Well,
ahead.
my question is, Raymond's unique in that we have a number of lakes.
Yes,
So, my question is that whereas I'm not gonna necessarily be an abutter to make a potential project, should we say,
Yeah.
but if that project is on, I'm not gonna say Sebago, because that's too large, but I wanna say one of the smaller lakes, do I have an interest, if, you know,
yeah, yeah.
because, so that, how do you handle that, where a situation where it's not clear with lakefront property?
Yeah. Yeah, I mean, I think that definitely falls into the category of if you feel personally that it's not going to impact your, you know, predisposition, you're going to be able to be objective about the application despite that connection, then I would say, you know, you could, to be on the super safe side, disclose that, you know, you live on this lake and this would affect potentially the lake, but you feel you can be objective and let the board vote.
Okay.
I mean, I think that's the safest way, but I don't think there's any danger that you are per se conflict of interest in that situation. I think, you know, it's tricky though.
Well, I have a
Is it
question.
similar?
This regards relation of the conflict of interest to quorum. We're supposed to have 7 members, but right now we only have 6. So let's say we have all 6 here for a meeting.
Yeah.
And a quorum would be 4. And if we only had 4 members there that particular night and one of them had a conflict of interest,
Yeah.
does that mean that the quorum rule is not met because now we only have 3 of 6? Or is, with the one being in conflict, does it drop down to 3 of 5? And is that still considered a quorum?
If you needed to have a quorum, if you needed 4 because you have a 6-member board,
Right.
then if somebody recuses themselves, then you don't have a quorum and you can't.
And we can't
handle-
consider it,
You can't
okay,
consider
right.
it. And actually, when people have a conflict of interest and recuse themselves, we recommend, though this isn't anywhere in statute, but we recommend that person actually get up and leave the building, just because there have been cases where an applicant will say, well, he got up, but he sat in the audience and he was making faces to the board members. And, you know, it just sort of removes any question about the issue. So in that sense, yeah, the person's not even in the building and you don't have a quorum.
That's, yeah, I remember reading that somewhere in here.
It says in our bylaws if there's a conflict of interest and if the member recuses themselves, they're still entitled to participate as a member of the public, so probably ought to change that.
Well, I mean, that's something to think about.
I mean, that's true, technically, you're still a member of the public and you're
Right.
still
Right.
interested in the town of Raymond, but being a member of the board, you may have an undue impact on the people that are still considering the matter at hand.
That's tough. I mean, I think that's going to be a policy sort of preference in your town, whether you want, I mean, certainly if you're an abutter and to an applicant and you feel strongly that this project should not move forward based on its impact to you personally, you know, it would be nice if you had your spouse come and offer that personal perspective so that you wouldn't be in that position
I
of,
believe the state of Maine
yeah.
guide for planning boards that are part of our great big notebook. I believe I read in there that you do have the right to sit in the audience.
yeah.
And I understand your point about that being considered undue influence or something.
It could be. I mean, that's, I think, just to be as safe as possible to protect the town's legal interests, that then removing yourself entirely makes sense. But if it's going to infringe on your personal, you know, right to speak on an issue, that's a balance. So I don't have a, you know, a black and white answer on that one.
Would it,
Yeah, because I wouldn't agree with these other guys. You're being impacted and you become a member of the audience. I guess I don't see why you can't participate.
Yeah.
disagreeing with me?
Were you saying? Oh, I'm sorry.
No, could we write into the bylaws that the board can, would it help you in your job if we actually took a vote saying, in each case, yes, the board member can sit in the audience and participate, or I don't know, because
Yeah,
I agree with Greg in this case.
I don't think
in this
that
case.
would be proper myself. I think it's up to the board member himself to either leave or decide he can sit in the audience. But for the other board members, not even knowing what his interest is or
No, I have to disclose it as
you know,
well.
how he may, interact from the audience to say, well, no, you can't be here. I don't think that.
Yeah, I mean, I actually think that what you just stated the bylaws say is not a problem. It's just, it's something, and that part of this training you should all be aware of, that if you end up speaking as a member of the public on an application where otherwise you would be on the board, that there is some potential where that applicant might appeal a denial of a permit on the basis that you unduly influence the process. So you have to be careful about the way in which you offer your comments and, and weigh that interest in protecting the town against
Well, then,
your personal.
At that point, who's quote in the wrong? The board for letting someone influence what they're thinking, or?
I think the problem would be.
Or
That's
for the
the
person
point. I
that
mean,
decides
if you were in a butter and the guy was proposing to do something that you felt was really going to injure your property values or do something terrible to your property, I would feel that you had a right, to present your views.
Right, yeah.
That's a tough one.
It is. It's definitely, it's not an easy question, because I think that the argument would be, and I've seen it in other, in cases where they say, well, he obviously had a lot of clout on the board. That particular board member was really well respected among his fellow board members, and they trusted in him that he would only say something that against a project when he really believed it wasn't going to meet the standard, even though in that case he's talking from his own personal perspective. And so, it's that kind of dynamic. And so if it was happening to me, I would feel the same way. I would feel like, well, I should have an opportunity to say my piece. I might suggest that someone else in my household speak, and I, speak and make the points that I would otherwise make. If I got up and spoke, I would say repeatedly, I'm speaking on behalf of myself. I don't intend to, exert any additional influence that anyone else would have in this scenario. This is my feeling as a, property owner abutting this project. And then, say your piece to do your best to protect the town in that scenario. But
It might not hurt the board to put in their findings the fact that they didn't consider anyone's opinion any more than as a member of the public rather than as a member of the board.
yeah.
That wouldn't be
Yeah,
a
so-
bylaw issue, that would just be a procedural issue.
But I do think all the points you're raising are exactly the kinds of things that you would think about, you would want to be thinking about if that happened for this board. And the perspective to have is, we just want to make sure that you don't end up having an appeal where we have to deal with that issue. But it happens. Sometimes you can't control when an appeal happens. So. Any other questions on conflict of interest?
I don't know, maybe
Yeah.
a good way to handle that, if you know in advance it's going to happen, is to prepare a written statement of your position on the issue, and then recuse yourself and just present the written statement to be read and be made part of the record without your presence. That might be a good way to handle it.
Yeah, I think that makes sense too. They're not easy situations. There is another provision in the conflict of interest statute that says that, and maybe I should read it, but exactly.
What is
But
the
it-
statute for conflict of interest?
You want to know? It's Title 38, Section 2605, and this is where it defines direct or indirect pecuniary interest. It has that per se definition of what a conflict of interest is. But as I said, case law may determine that you have a conflict of interest with some lesser interest than is described there. But it also says every municipal and county official shall attempt to avoid the appearance of a conflict of interest by disclosure or by abstention. And so that's sort of what we've been talking about so far, which is even if you don't meet this definition of actual conflict of interest or per se conflict of interest, if someone might think that it looks like one, disclose it and possibly abstain from or recuse yourself from the proceeding. It's a kind of tough provision to have in a statute because it doesn't tell you exactly what an appearance of a conflict of interest is, but it's sort of another indication that, you know, we need to be careful about the way this stuff looks to the public to make sure that the integrity of the process is maintained.
It seems like that, obviously that statute goes farther than our bylaws, so which governs?
You are required to follow the statute, whether it's in your bylaws or not. So, you know, that's something it might be worth thinking through. Trying to see in your bylaws where the conflict of interest is.
Article 6, Section 5.
Is there a statement in the bylaws that we are required to follow state statute?
No.
And that over governs any restrictions of the bylaws,
No.
per se?
It doesn't say that now. You could certainly add that to make sure that, you know, you all and future planning board members aren't confused about that question. You know, does the statute apply or can we just follow our bylaws? It doesn't, you know, this section 5 under Article 6 really doesn't describe, it really just describes the statutory description of conflict of interest. It doesn't go beyond. And I'm not sure, I think a reference maybe to state law generally would help. But it's important to know that there's, the statute doesn't get you, you know, the whole way home anyway, because there's case law that is based on, it's not based on state statute, but it's based on the common law of, you know, the way in which these kinds of proceedings are supposed to occur. And so, you know, a judge could determine based on common law that there is a conflict of interest and it has nothing to do with the way the statute is defined. So I guess my point is you're not going to have a perfect set of bylaws that's going to represent all scenarios. And I think what you want to do is have language in there that at least makes it clear this is an area to be very careful about.
Would you draft some statement for presentation at a
Yeah,
continuation of the workshop as to how we might include appropriate language to that effect in the bylaws?
Yeah, I'm happy to do that.
You were going to get into bias also, weren't you?
Yes, I was.
Okay,
Yes.
good.
So bias is an area that is not in statute at all. That's really a common law, judge-made, you know, kind of concept. And it's, I think, even harder to put your finger on than conflict of interest. But essentially, bias is trying to address where you are bringing a predisposition or a prejudice to a situation that really colors your ability to be objective in applying the standards that you need to apply on an application. And so, you know, one example is where there are really vocal opponents to a project and a member of the board is one of those really vocal opponents. That's a scenario where, you know, I think the town may well be at risk of having a bias claim if in fact that person is the deciding vote against the project. That would have to be, you know, the resulting decision in the end. It would have to have made a difference that person with the alleged bias, you know, was a determining factor. But it depends on the facts of the situation. It depends on, there would have to be a real open discussion, like we talked about with conflict of interest, about that individual's predisposition. If there's someone who's been really actively against certain kinds of development, and then they are on the planning board, you as planning board members are charged with applying the ordinance standards. And your, predispositions about what kinds of development are good or bad should have no bearing. I mean, it is a distinction between a legislative body and an adjudicatory body. You are really an adjudicatory body, a judge-like body, rather than a legislative body like the Board of Selectmen or the legislature, who those folks are really deciding what's good and bad and what should be law and what shouldn't be law. Planning board, zoning boards, you are applying the law. And that's a real distinction, and that's why bias is an issue for you all. I mean, it would be an issue for judges as well. Does that make sense?
Yeah, it does. The Main Street Planning Board has some words about the bias issue in it.
Yeah.
Their guide, which I think is pretty clear. If I read section 9 correctly, all decisions must be based on page 4. All decisions must be based on whether the applicant has provided sufficient evidence to prove that all applicable law and ordinance requirements have been met. That sentence doesn't use or address the word bias in any form, but as I read that, it really puts the bias issue to rest, because it takes your personal feelings out, and you don't
That's
feel
right.
that statement is sufficient as it stands. It doesn't need to be amended or played with at all.
I mean, I think it depends on how explicit the board wants to be in adopting bylaws and really addressing the bias issue. But I agree with you. I think that is getting to
Pretty
the same
clear.
point.
Yeah.
And part of this is, I don't know to what degree your bylaws should act as a training manual, so to speak. But this is really the conversation that you would have in periodic training about, what bias is, and sort of a self-check on, what you're doing as in your role as a planning board member. But yeah, I think I like that language.
You might touch on the duties of a board member if he does feel he is so biased that he can't make a logical decision based upon the facts of the case, as far as either recusing or abstaining. You might touch on that so everyone's clear.
Yeah, I think it is very similar to the conflict of interest advice that I give, which is if you think you are not able to be objective in applying the standards, then you need to disclose that to everybody and recuse yourself and remove yourself from the proceeding.
Or abstain on a vote on a particular portion of an application.
Yeah, you certainly could do that. I mean, if you know you're not going to be objective, then you might as well not participate at all. Because part of the reason you might be concerned about participating in the questioning of the witnesses and everything, and then at the end abstaining, is that your questions and your participation, an applicant may say, were part of the reason other board members voted the way that they did. So, it's a stretch kind of an argument for an appeal, but it can happen. And so to most effectively protect the town, if you know you're not going to be able to be objective, you should recuse yourself and stay out of the process.
There may be portions of an application that you feel that way on, and I've struggled with that a little bit, and in the main hand guide, they also talk about abstaining on an application or a portion of an application that you feel you can't, judge on its merits.
I do think, if you get into a process and then you realize you're really not in a good position to be objective, then you should feel obligated to abstain, despite the fact that you've participated up to that point. I think that's still, you know, the proper course of action, even if you haven't, up to that point, removed yourself.
My question is, how does a board member's role in outside organizations apply to this? This does not apply to me, this is totally hypothetical. But let's say I was a Boy Scout troop leader, and then we are considering a project by the Boy Scouts. Being a member of an organization, does that need to be disclosed?
I would disclose it if I were in that position, and if I felt like it was going to make it impossible for me to be objective, I would probably not participate. But if I didn't feel like it was gonna make me be, you know, if it wasn't gonna interfere with my objectivity, I would
But-
disclose it and offer the rest of the board the opportunity to kick me out for that process.
In a bias case, that could though, if you didn't disclose it, that could be used as if they wanted to, okay.
Yeah.
I remember we had one case, I don't remember what the application was, but one board member who was sitting just disclosed their membership in an organization or some tangential relationship and asked if the rest of the board felt comfortable in their continuing to sit on this, on consideration of that particular question, and the board felt unanimously that whatever it wasn't a problem, so, yeah, that's another good way to
Yeah.
handle it.
Yeah, I think that's good. Did you have another question? Okay. That pretty much covers my points I wanted to make on bias. Any other?
A lot of professional organizations have a code of ethics. I don't know if that would apply here or not. All that would probably do would be sort of guide someone in how to address these things. And,
You know, the town of Raymond has a code of ethics, right, Danielle? You've got a one-page code of ethics that I thought, maybe it's just employees, but it may be town officials.
I think it's elected positions, I don't know
Okay.
about volunteer positions,
Okay.
I have to check. I'm
Yeah.
pretty sure it's elected.
And I'm not sure off the top of my head if that document covers, you know, these kinds of issues, or if it's
They may simply
focused on
not fit
something
in
else.
this. I
It
don't know.
has a
I'm not one
bunch
for making
of,
things more
hold on.
complicated.
Let's see.
I mean, you know, one of the things that you might consider is, you know, this section 9 that you just read, if you want that to be more prominent in your bylaws, you know, you could put it in a more, you know, at the beginning of the document or something like that. That's one way to kind of make it a little bit more, I don't know, impactful. You know, this is our job, we're applying the standards. But yeah, I mean, I think if the board wanted to include some other kinds of language in there,
I'm not uncomfortable with the statement as it is.
Yeah.
I seems to be pretty clear, really. Thou shalt do this,
yeah,
which by extension says thou shalt not do that.
right.
Well, actually, the board, since I've been on it, we've run into these little things, and as far as I can see, we've always acted right on them, in my opinion.
It's
And we
good.
did just like, you know, you said, you recuse yourself, you present to the board that there's a potential conflict and ask the other members.
It's funny, some of the stuff is actually common sense.
So I think we've been good.
That's good.
But
Yeah, our code of ethics references Title 30A 2605, conflicts of interest.
Okay.
And
Okay.
talks about, you know, basically staying away from those sorts of issues, so.
Yeah, yeah.
And actually, it looks like it's for appointed and elected positions, so I think.
Well, so you do
that-
have a code of
Say,
ethics.
I got one when
Did
I
you?
joined the board a couple of months ago, so.
Yeah, I couldn't remember because I stay out of that part.
Well, that's interesting. It might be useful to make sure everybody sees that. You may have gotten it and just forgotten about it since you've been, you know, on the board, or you may never got it.
I missed what you said. You said for appointed,
Yes.
elected people?
Appointed and elected, yeah.
Oh, neat.
So you do, good idea.
It's relatively new. It
I'm
just
done.
came out in about 2 years, two years ago, so I don't know. She probably has you signing them as you get renewed, so.
Yeah.
I'll send that out right now.
All right, well, I was gonna move on to the, just an explanation of what happens if a decision gets appealed. And it will, in doing so, explain the reason for the findings of fact and conclusions of law decision. But there is a right that any applicant that's denied a permit, or anyone who has standing to challenge a permit that's granted, to appeal a decision of this board to the Superior Court. And in fact, I should have checked this. I know Mary is up on this, but I think your shoreland zoning ordinance allows the appeal right to Superior Court.
Correct.
And your land use ordinance allows for an appeal to the
Appeals.
zoning board first,
Yep.
the appeals board first, and then, so that's a little quirky in Raymond, but in any event, anyone who's coming before you has the right to appeal your decision. And the reviewing authority, whether it's the appeals board or the Superior Court, they will be giving deference to your decision. It's always nice, for that reason, to be on the town side in an appeal situation, because the burden is higher on the applicant or the abutter that's making the appeal. You get deference. So what they do is they don't look at the whole application from start to finish, which would be something called de novo review. It's an appellate review. And what they look for are whether the board below abused your discretion, made an error of law, or made findings that aren't supported by the evidence that's in the record, by substantial evidence that's in the record. And those are the three things that anyone appealing they're gonna try to show. So when you are creating your findings of fact and voting on, the applications rather, you want to be thinking in your mind, are we in some way, stretching these standards or stretching the situation so that we can, either find in favor or find against this applicant, so that they could argue you're abusing your discretion. Are we committing some kind of mistake in the law or error in the law, which you should have, some guidance from your town staff and an attorney, if you've got one on that application, on that issue. And then the findings need to be based on substantial evidence in the record. That's a little bit tricky. That's something that should remind you all of, as you're going through the process, you want to make sure that if you know something about an application with respect to a certain standard that hasn't been disclosed by the applicant in written materials or in questioning or by witness, you want to elicit that information by asking questions so that those answers get stated on the record. And sometimes that'll happen where, something gets stated that doesn't really fully address that standard. But you kind of just say, well, we're pretty sure that's met, or I happen to know from outside of, you're thinking you happen to know from outside of the context of the meetings that this is met. It's got to have been stated on the record, and you have to have a way to point to it, so that if it gets appealed and I'm trying to find what we based all these things on in the record, I can find it from a transcript, or I can find it in an application somewhere. And that gets to making sure the stuff that you're going to base your decision on is in the record. It also it's something to be careful of if you've got evidence that's being presented outside the context of the meeting, or outside the context of only being presented in deliberations as opposed to the presentation by the applicant. You want to make sure that the evidence and the facts that you're using to base your decision on were presented by the applicant or a witness during the process. And So, you know, those are the kinds of things that come up as an appeal moves forward. And that can help you best protect the town, you know, because usually what happens is in the substantial evidence in the record component, it's often not about whether there is substantial evidence to support something, it's whether it was actually in the record. And that's what we have to prove. So no matter if you know your decision is right, it's got to be supported in you know, what was presented. Does that make sense? Any questions? You have a puzzled look. Good.
My question is, if an applicant makes a presentation
Yeah.
and actually presents something that is wrong, if no one from the public, no one else challenges that, does that wrong statement considered substantial evidence in the record?
Well, remember, that's a good question. Remember, the appellate body, whether that's your appeals board or the Superior Court, gives you deference. So you decide you don't believe the applicant. You have to have something in the record to support why, you know, you don't believe them. I don't know, it's hard to say without the specific example, but if you have something else to point to that standard isn't met for some other reason. You might state in your deliberations that you don't believe the person, and this is why. And I think that, you know, that could be fine.
Because this actually comes up,
Yeah.
the question that Mary, when in
Yeah.
a recent situation, said that anything that we have, and we're saying, cannot go into the record. It has to come from.
Yeah, well, I mean, that's what I'm getting at. I mean, I think if someone says something, if the applicant says something and you don't believe it and nobody challenges them, you should be the one to challenge them while they're talking and to say, you know, but what about this? But what about that? So that it's in the record at
Okay.
that stage. If it's not until, you know, your deliberations where you say, actually, I don't know the specifics of the circumstance when Mary was here, but if it happens that you end up just saying at the deliberation stage, I don't believe what they
Okay.
said, that makes it harder for us to defend, for sure.
So our questioning of the applicant does go into the record as substantial evidence in the record.
Yeah,
Okay.
yeah. Yep, I mean, their responses, whether they are satisfactory to you in your judgment and whether the standards are actually met, that's relevant, sure.
I think that's an issue that comes up, but never gets addressed here, is often, some board members here have a lot of personal knowledge of development, because of their jobs, of their careers, they know a lot about runoff standards, for example. And so, applicant comes in and says, I've done this or that, and then someone on the board might know more than that, and say, well, that really doesn't apply because it's this and it's that. So, in those cases, I always feel inadequate, because I don't have that knowledge base. So they're making a statement that's contradicting what they've said, but they're testifying almost based on their own knowledge. Instead of getting them to, the trick of the procedure is to get them to acknowledge. I mean, isn't that the point?
Yeah, I mean,
Otherwise, it's testimony, you're an investigator almost.
that's right. I mean, you're the judge, like what we were talking about before. You're the judge, you're not, you know, an interested party here testifying as a witness. So you may have personal knowledge and personal, you know, backgrounds that help you understand the applicant and maybe can better judge whether they're credible for that reason. But you've got to elicit the sort of evidence about whether they're credible in that questioning and in that testimony. And so when you get an application and you say, well, this standard is really, that's not right, you've got to bring that out in the hearings that you have. It's not always fun to put people on the spot, but it's better than waiting until the deliberations and then voting a certain way that, you know, then you can put everybody at a little bit of risk.
It's sort of the same thing, when somebody brings an expert witness, so to speak, to say this is all good.
Yeah.
And then we still don't think it's good. So is it then our job as a board to go find an expert witness, to
Yeah.
ask better questions, or to require them to find a different witness, or where would you go with that?
Well, that's a good point, and Danielle, you may be able to help me out whether, I mean, in a lot of towns, when an applicant comes in with their own expert, the town doesn't feel, and there's no opposition necessarily that would bring their own expert in. The town would feel like a peer review would be necessary. And there are occasions where other towns use peer reviews. Does the town use?
Yeah, that's optional
Yeah.
at the discretion of the board.
Yeah, yeah. So, I mean, I think that's definitely an occasion where you would want to do that. And that is a good opportunity to, rather than bringing your own personal knowledge, but you can say, well, okay, we need to get a check. And this is a way to put some other evidence in the record that may contradict them. I think that's a very good point. So the other couple of points I wanted to make about decisions is conditions. Do you place conditions on approvals often? Yeah. Most planning boards do.
No.
Yeah.
Always.
Yeah, yeah, I mean, so I get this question a lot is, how far can we go with conditions? Does it have to be related to the project or the application? And it really should be related to making sure that the applicant can meet all the standards. So, you put a condition in place that will ensure they really are going to meet XYZ standard that they need to meet to get the permit. That's the safest way to impose conditions. That being said, if an applicant willingly, agrees
Offers to do something.
if they offered to do
Once they say
something.
that, that's it, right?
Yeah, if they're willingly gonna say, yeah, we'll build a park over here, even though it's not related at all to our, project or anything. If they're gonna offer to do it, they're gonna offer to do it, and that sort of, I think makes it okay. But when you are coming up with conditions saying you're not getting this permit unless you do it, you gotta make sure it's related to a standard.
Yeah, the condition has to be reviewable, and there has to be some degree of accountability to the condition, or there's no point in putting it on it. It's either a condition that has to be met in order to get a permit, or it's a condition of 6 months or a year down the road, there's going to be some type of a review of something that was built in the field to see if it met the conditions for continuing operation. I guess
Okay.
is a good way to put it.
Yeah, and that's actually one thing I wanted to talk about, which is enforcement of your decisions. And I've had planning boards ask me, well, what do I do? I have, neighbors of former, people who got permits and did a development, and neighbors call me and say, they never put those trees up. And you as a planning board member say, I don't know, what am I supposed to do? And, you're really not in a position to help other than to say, that's the code enforcement office's responsibility. I'll bring it to their attention, but, that's not something you personally can do anything about. You did your job, you put the condition in there. And, I think most residents who feel like somebody should be doing something that they aren't, know to call a code enforcement officer, but they may not. They may have participated in the planning board process and they view you as the town official that's relevant to that situation. But that has become an issue for some other planning boards. Have you ever received calls about that kind of issue?
I never have.
Good. Okay, well, that was, the sort of practical,
I got a
yeah,
question.
go for it.
In the beginning of the meeting, Bob or whoever the chair is reads a whole list of things that the applicant has to do, and like if he wants to appeal it, how he appeals it and that sort of thing. Would it be appropriate that if we include in that reading that if an applicant offers to do something that's not in the ordinance, that they're committing themselves to do something they might not want to do?
You mean
Earlier you
offer to
said
them?
that
Yeah.
if you can get an applicant to say they'll do X, Y, and Z, then you can make them do it. But if it's not in the ordinance, you don't have any authority to tell them to do it. And then when we're reading that open statement, should we make it clear to them, if they make an offer to do something, they're obligated to do it, even though it's not in the ordinance and we want to enforce it?
You know, I don't think it's necessary. I mean, I think if an applicant,
Applicant beware.
well, they need to be sophisticated enough to understand that you can only bind them to do the things that they have to do to meet the standards. They have the standards, they have the rule book and the ordinance, and if they're gonna willingly offer to do something that's off the map, I think they should know that. I mean, they should already know that. I don't think that rises to the level of we should
Yeah,
put it in the decision.
It wasn't in this planning board, but I remember watching a person go before a planning board, and the planning board said, well, would you put a survey pin in the middle of all these campsites so that we know that you haven't moved them around? And it's nothing in the ordinance, and the person that was representing the applicant said, oh yeah, we'll do that. And, you know, maybe the applicant didn't want to do that, and maybe the guy representing the applicant didn't understand that once he said that, the planning board could hold him to doing that.
Well, I mean, I think
I
it's,
watched that happen, I said,
yeah.
you know, I wonder if he knew what he was
If he
doing.
knew what he was
because it
doing.
You know, with GPS and all that, I don't know why you need to put a survey stake in the middle of a campsite, but.
well, I do think the safest thing to do is to stick to conditions that are relevant to the standards. And I can't really think of an example where you'd really want to go off the map unless the applicant.
We do with cisterns, we tell
We do?
people to put in water storage tanks, and we don't have any authority to do that. We did that with Rosewood.
Yeah, but the applicant can't make an inducement of performance to sway the board to make a decision that doesn't conform to the rules and regulations we're supposed to be using for making a decision. So I think if he wants to make an inducement that's, you know, goes beyond, as you say, off the map, that he's certainly free to do that. That can't influence our decision, and he can't use that to sway our decision. So I'm comfortable with it the way it is.
Yeah, but I can see where you're coming from, Greg. You do want to be cautious about, you know, letting them think that this is a quid pro quo. Because it's not, you've got standards.
You know, I mean,
Right.
you've got a good point. We need to make sure the applicant knows that we are making our decisions based upon the rules and regulations and the ordinances, and that inducements or promises or back rubs or anything else are really beside the point.
Yeah.
Yeah.
I don't know. I've thought about that many times. I figured it's a good time to ask, and
Yeah.
about reading that statement and including.
Well, some of our ordinances are somewhat vague. And let's say the safety issue. One, you know, project we're looking at right now is, there's a lot that can go into safety. And so you can actually ask the applicant to do a lot from a safety perspective. Is that, those conditions, are those directly related to the? I mean,
Yeah, I mean, if the board, in the board's judgment, they have to, you know, put a crosswalk in or do X, Y, Z in order to meet that standard, that's a condition that works. I mean, I think the other piece to consider is there another measure they could take or something else the applicant could do to meet the standard? And that's something you kind of have to figure out as you go, but But yeah, I mean, if it is related to safety and it is necessary for you to find in favor of the applicant on that standard, that's a condition you can involve.
You know, I think that's part of the beauty of the board review process. If you have everybody looking at something from an unbiased viewpoint, considering the requirements of the statute and what works and what doesn't and what's right and what's wrong, most issues are going to become pretty clear cut. You're not always going to have 4 to 3 votes. It seems to me more often on something that's really definitive, you're going to have 5 to 1, 6 to nothing, whatever votes. The difference of opinion on something that's pretty cut and dry generally won't be split.
Mhm. Okay. Good on conditions? So the last thing I won't spend much time on is the Freedom of Access Act, because as I said before, that's really, it impacts you all less. You have fewer occasions where you would have you ever been in an executive session as a planning board?
I haven't been
So
involved
rarely
myself.
happens for planning boards. So, general rule is that all your meetings are public. All of the documents relating to your work as planning board are public documents. There are some exceptions to that. But the other piece that can get planning boards and zoning boards tripped up on occasion are site visits and email. So, to take site visits, first of all, do you do site visits as a board frequently? And they're hard to manage on occasion, but I mean, presumably you notify the public that you're having a site visit ahead of time, and you show up there. And the part of it that is tricky is at the actual site visit, you want to try to allow for whether, if the applicant is there showing you around, you want whatever questions are asked and whatever answers are given to really be heard by everybody who's there. And when you're traipsing around, in the snow or in the forest, it's not easy to manage that. But that's something you want to try to be aware of, because you don't want to be in a position later where, a couple of board members are relying on something that was said or explained at a site visit that no one else heard, even though there were a lot of other folks that were there. So if you hear something that you think is really relevant at a site walk, it would be good to encourage whoever it is to repeat it so everybody hears, or to repeat it yourself so everybody hears. Does that make sense?
And that goes back to the substantial evidence in the record.
Exactly. Yeah, it helps in that regard too, in addition to the Freedom of Access Act. So that's kind of a little odd about site visits. Then email,
Can I
most.
ask a question about,
Oh, yeah.
that case, shouldn't there be minutes from a site walk?
There are.
Yeah.
No, that, basically, we do that, so.
We got minutes from the last
Yeah.
sidewalk, right?
So that covers that pretty well,
Yeah.
right?
Yeah, it should. I mean,
As long as everybody's together.
it depends. I mean,
You guys are like baby ducks, like.
yeah, I mean, I think the minutes are taken so differently in different towns for different meetings. I mean, some towns' minutes are so bare bones that you don't really know what happened. It just says, we did a site walk.
Oh, those are
We
good.
finished the site walk.
Yeah, those are good.
So, so that's a little bit, but yeah, it helps to have minutes to make sure there's a record that it occurred and who was there roughly.
Actually, this, Danielle, you probably, isn't it stated somewhere in Raymond or that the video is the official record
Yes.
When
We
the
don't-
video's available.
when it's
Yeah.
available? So there,
Obviously,
in
if
our
you're not in the
bylaws.
broadcast studio or where we have, set up, then that would be an exception
so there wouldn't be a
to that.
requirement for a videographer to be walking around.
Yeah, that would
I'm
be
just-
I don't
onerous.
know, I don't, I've wondered that, but I figure while I'm there and, I try to do my best to capture.
But
your
does it
stuff
say that
if
it's,
you-
does that, I don't have it in front of me, does that state when available?
No, it just says as of 2010, the official record is the video, but,
Is it considered a board meeting, the site walk?
Yeah. Mm-hmm.
yeah.
Technically, I'm supposed to be there.
Well,
How
I
do you
mean,
think of that? Well, according to, they said that, yeah, I'm supposed to record, I mean, under my rules, I'm supposed to record every meeting. So
I don't
if it's
know.
considered a meeting, I'm supposed to record it.
In here?
I mean, I think it's pretty unrealistic to require
Section 2, I'm sorry.
video for site visits, but, so I think we could interpret it to mean what, you know, you're saying, Danielle, which is, if we're here in the studio, if that's the official record. I mean, a transcript, if a decision gets appealed, we often do transcripts so that we can figure out what exactly is in the record. But if you take relatively detailed minutes of site walks, and you're all careful about whatever is said being repeated, to everybody who's there to hear, and then when you get back into your meeting to ask somebody to repeat what they said or what they saw, that'll help too.
I guess I would
Yeah.
I would ask that someone take a look at Article 5, Section 2, and, you know, obviously, right, not tonight, but I
Yeah.
mean, because it does say that DVD is the official legal record of the meeting.
Yeah, then if you have an opportunity to change that language now, we might as well. If it's in an ordinance and you gotta change it that way, that
No,
makes
it's a policy decision by the select board.
Yeah,
Okay,
we can't
okay,
make that decision. The Board of Selectmen would have to issue a new order as to what our official record is.
Right.
yeah.
Because we didn't
Interesting.
make that decision in the first place, so.
Yeah, that's a good, that's something we can follow up on.
Because I think only up until recently have you guys even had a secretary go out on your
site
sidewalks.
visits,
Yeah,
yeah.
it was part of a training. They said that anytime there are more than 3 of you together, I mean, that I have to be there.
Referee.
So,
Well, 3 people on a board is a meeting under the Freedom of Access Act. So you have to make sure if that's ever gonna happen and you're talking about town business, that it's a publicly noticed meeting and that you've got some record of it, which minutes, as I said, are
I
very
found a good way to
great.
behave at sidewalks is just to keep in mind that it's really it's not only discovery, it's making sure that the applicant is given his due process, and all the courtesies he would be extended at a scheduled meeting, because it really is an official business, function of the planning board for discovery and finding out what the merits or demerits of an application are, and letting the applicant state his piece in the field.
Yeah,
Yeah.
yeah, that's great perspective. So email was the other thing I just wanted to touch on. You probably, am I right, get emails about when your meetings are, timing, do you get your packets by mail or by email?
mail, but if we were just
Sometimes,
talking about that, that we've had a lag, so I try to do both. Like I'll send out whatever I have digitally and then
Yeah, yeah.
send it paper.
Yep, and all of that communication is fine. What is dangerous for planning boards is to, you sometimes may be tempted to respond to all and bring some topic up that's relevant to the application, that isn't just about when or where the meeting is. And that's where you're in the territory of, you may be creating a meeting by email that should be open to the public. So that's the theory, and I think it does and has happened for other boards where, you know, a staff member will send out a piece of information and it will be so tempting to comment on it right away that there's the reply all, and this is, you know, and you start to talk about the merits, and that's really a violation of the Freedom of Access
And I've
Act to
seen
do
that done.
Yeah.
There was one instance where we got a lot of public comment on an application. I know one
Oh, I
member of
bet.
the board
Yeah.
came back with an email and said, something like, who are these people anyway? And you have to be careful about things like that, because that creates invitation to creating a possible prejudice against the applicant or some position that's going to be presented in front of the board. You really have to be completely neutral and try to use email as little as possible. Just make it scheduling, I'll be there at a certain time, the meeting's on a certain date, yes, I got the package, whatever, and just cut it off at that. Don't go any further.
Yeah, yeah, so for the reasons you just described, to make sure it's the integrity of the process is maintained, but also because the Freedom of Access Act, you may be creating a public meeting that,
Right.
by email. So, yeah.
One statement, one question. The way I've handled it, and Danielle probably hates me for this, but everything goes to her in a single, so I wouldn't, if I'm gonna respond, I respond to her, and then that's, so I view that as kind of going through the town office, and then she can disseminate from that. Is that legal? So if I
Well,
wanted to.
it depends if she's disseminating it to the rest of the board and it's something that really should be communicated in the context of a meeting. If
Well, we
it's
have a communications section, so that it would end up going into
Yeah.
a packet
The
or.
meeting, yeah.
Right.
Oh, I see.
And the other question is, this is I think a little bit harder one, and it's only happened to me a few times, members of the public emailing us directly. And
Calling us.
not everybody.
Right.
So, my response to that, again, I send it on the same avenue.
Yeah, I think that's a good approach, is to send that on to the staff, and either Danielle communicates directly with that person to explain to them how they can make official comments on the record and come to the meeting, or you do that and cut it off there. But it's impossible for you all probably to avoid having some communication with members of the public about applications. You probably will have to face that at some point if you haven't already. That's less about the Freedom of Access Act, and more about making sure that whatever you are basing your decision on is in the record. So you got to make sure that those individuals aren't thinking that they're convincing you of something outside the context of the meeting. Come to the meeting and say this to the board. We really should, I can't base my decision on our conversation. That kind of response, I think, is a good one. And to direct them to Danielle and the meeting sort of specifics and logistics and how they can submit evidence or comments in writing.
And I've been put in the position, and I know other board members have been put in the position where somebody calls you at your house and starts pigeonholing you, asking your opinion on something, trying to convince you of the merits of their position on something, and you really have to just treat that as almost really part of the due process, that I can't discuss this outside of a meeting. The applicant is deserving of due process in an open meeting, and it's something I simply can't discuss. And if you feel that it's important to send an email out to other members of the board and to staff that you were contacted by this person, and they were trying to sway you and ask your opinion and get you involved in a discussion, and that you shut that down and you encouraged them to come to a meeting, and that you weren't going to conduct any of the business of a meeting outside of a meeting, and by reporting that to other members of the board and to the staff, you've really short-circuited the ability of that person to come back and use your conversation as any proof of bias or
Yes, yeah.
wrong adjudication of a particular issue.
Yeah, that's great. I'm glad you said it that way. Yeah, it's not easy though, because people think that they see in the grocery store they have an opportunity, and like you said, it needs to be something that happens that's open to everybody in the process. So the other thing about emails to consider is that any email correspondence you have about town business, I like to suggest to planning board members that if you are sending emails or having any written communication about town business, that you have a town staff person copied on the email. The reason is because if the town were ever to have a Freedom of Access Act request for all documentation relating to X applicant, that any of your personal emails would be part of that request. If you know for a fact that Danielle was copied or someone else was copied at the town office, then you don't have to be concerned about looking in your personal emails for whether, and it's probably not a good idea to be sending emails about the substance of applications at all. So, you know, you may not be in that situation anyway, but I would make sure, if I were you, not to have any email correspondence where Danielle is not copied or someone at the town office is not copied.
That's why Danielle sends a lot of emails out to us when she receives comments from constituents. And I know the
Right,
reason for
right.
doing that is so
Yep.
we have a chance to review those comments before the meeting. The question I have is even though there are time constraints on her being able to mail those comments to us in a packet, or she receives comments after she's mailed something out to us, I'm concerned that opens the door
Yep.
for wrong responses from board members in response to her emails that she's just sending out for informative purposes.
Yeah, it's a preference, really. I mean, if you think we can all be responsible enough not to succumb to that temptation of reply all, then, you know, the way Danielle's doing it works just fine. But, I mean, in a lot of cases, I tend to agree with you, where if you can, you know, as the risk-averse attorney that I am, by the nature of my position, you know, trying not to present people with the temptation is you know, advisable or recommended. So it comes up for me when I'm asked to report back to a board of selectmen on an issue, or a town manager, and a town manager sends it on to a board of selectmen, and it's really hard to make sure that that group understands we can't get into a conversation here. This is a one-way communication. And so, I mean, I think if the understanding here is that that's a one-way communication and you all understand you're not supposed to respond substantively, then it works okay.
Well, from a legal standpoint,
Yep.
here's a question I have about that, and this is, you know, playing devil's advocate. If there was something, just as something that is emailed to us that an applicant sends in late that wasn't turned in at a proper time, it's not part of a proper application. And if an email is sent out that has members of the public giving us advice or telling us what they think about something, if a member, say a couple members didn't get an email and everybody else got it and the email became a topic of discussion at a meeting, and the couple of members who didn't get that email weren't informed about what was in it and couldn't discuss the content, does that create any legal tangles for the town on an appeal or, you know, any other further action down the road?
Well, I mean, I definitely think if there is a conversation about a substantive email that only went to a couple members, the other members need to have in front of them what that email said for it to be something on which you base a decision.
That's why we have to have those emails in writing as part of a packet and not rely just on the electronic transmission.
Yeah, I mean, I think the electronic transmission only works if everybody gets it, and it's part of the official record that can be made available to any member of the public who asks for it. I mean, one thing you said was if an applicant doesn't submit the materials in time to be considered, then it's not part of their application. That's true, but if you are leading up to a meeting where you're going to have a public hearing, and leading up to that meeting, you get a bunch of electronic, you get a bunch of emails with substantive comments, I would treat those as public hearing comments that are written instead of spoken, so that you really are going to use them in the record to the extent you feel that they're persuasive on standards, and that, to the extent you're going to rely on them, make sure on the record that people have notice of what they say, and, does that make sense? Because you're interested in preserving the due process rights of the applicant, but you also have an interest in making sure that the members of the public who, can't make it to the public hearing or want a chance to participate, and are abutters, and they may have standing to appeal an approval of a decision. And if you didn't, if you completely disregard, anything that comes in after a certain date, I think that's not the safest path. So that was pretty much the material I wanted to get through. Does anyone have any more
Anything?
questions?
My only question is about like how I can, I guess, serve the board better through the procedures and process, because, we're becoming more of a digital and electronic age where, physical materials are kind of harder to come by. And as you said, when I have people emailing me comments right up until I'm walking out the door or coming here, what's the cutoff point? I know now we've reiterated the fact that if an applicant doesn't submit something by the time the packets are mailed out, then they don't get to submit it. They don't get to discuss that. They have to come back another time. Like, do we want to enact something like that with correspondence, that I publish almost a cutoff date like I do with the Board of Selectmen? Like, because the Board of Selectmen, you have until like Thursday, how does something like that work where, correspondence is an immediate thing? Like, how do I make sure I'm getting the materials to them while at the same time, some of them probably have cell phones where it goes right to them, so, they're constantly, and then other ones may not. So what's the standard in terms of making sure that the boards have
Yeah.
access to all the information in real time?
That's a very, very good question. I think the balance is really, if you have a public hearing that's gonna happen and you're getting comments from the public, I would be concerned about saying, we're not accepting these, if they're submitted, sometime during the day of that meeting, and you have the ability to bring them to the meeting. I think you can say the expectation is that, people will submit written comments by a certain time in advance, but I wouldn't be too strict about it in practice, because I think they might have an argument that I wanted to offer these comments and there was no way for me to attend, and this was the only way I could offer my comments, and, I had standing.
Well, I'll ask the members who've been on the board a lot longer, in a situation like that where you're getting that many comments right up to the end, have you ever approved an application on the day of the public hearing? The evening of that, in that meeting?
I think there have been some occasions where that's happened, but it's been a pretty simple application.
But then you weren't getting
No, they
flooded
weren't
with comments?
No, we
so-
weren't getting 100
So,
emails
but,
on
you know,
it. That
those
would be a
comments could
simple
still get into the record, and we could still consider them,
That's right.
even though, honestly, if I don't get it by noon,
Yeah, you're not gonna read it.
I'm not gonna read it until probably after the meeting, so it would still get into the public record, we would still be able to consider it, and there would be the possibility of saying, well, we got 20 letters came in after noon, we're gonna table the applications until we can consider those public comments. Still gives us a way to review them without having to try to kill ourselves to get them.
Yeah, because there are times where I'm coming in here and I'm handing out stacks of papers on their desks, so they have
Yeah.
access to all of them, but
Right, that's not, if you are gonna be asked to make a decision that day, then that's a different situation.
Is there anything in the language that you deal with, Danielle, that mentions emails from the public as a proper form of communication and input?
with the Freedom of Information Act, it's once they email me, it becomes public record, and I have to treat it as correspondence that goes to you folks. I know that as part of the procedures of how I was taught to do this position, Before it was, like, you know, bundle them up as communication and send them to the board, but as I said, now with email, it's almost instantaneous. I get some letters, as you folks see, but most of it is, I get bombarded with
Oh, yeah,
email, so.
Isn't it simpler than that? I mean, the issue really is, there are two. One, if it's an applicant, and they have a deadline to file, that's pretty
Right.
clean cut. There's
Right.
nothing to deal with that.
Exactly,
The other would be public comment.
right.
Well, if we've already had a public hearing, then there's no more public comment.
That's what I'm wondering. Yeah,
So, if you haven't had a public hearing, or you're not gonna have a public hearing, it seems to me they can send anything and you process it like you normally would.
Yeah, what's the,
Yeah, if the public hearing has been closed, then that's not officially in the record if it's submitted after.
Exactly.
oh.
I mean,
didn't
that
know,
doesn't
yeah.
Oh,
mean,
that's-
that doesn't mean that,
important.
that doesn't mean that you won't read it, but it does mean that if you base a decision on that
Wow.
material, we're gonna have a hard time in court.
So I think the public needs to be basically told, when you close the public hearing, any emails, letters received after that point.
Won't
Maybe
be
we
the
shouldn't
basis
even be
for a
getting
decision.
those emails
Yeah,
after the public hearing.
how do we handle that? Cause I was literally bringing these guys
Yeah, we kept
emails,
getting-
Sometimes
you
they're
know.
Weeks, we kept getting weeks after the public
After
hearing.
the
Well,
public hearing
I think
before.
No.
it's unlikely in that scenario that you are gonna base a decision on what you receive in those emails. If you feel the need to do that, then I think then you have a vote to reopen a public hearing and talk about it.
Yep.
Exactly.
But I don't think you're likely to be in that world of, what you get after the close of the public hearing and email is determinative of standard.
What
Um,
might not be a bad idea, at least for the public's sake, is the people that send those comments after the public hearing has been closed, they're informed that it will be forwarded to the board, but it's not gonna become part of the public record because the public hearing has already been closed. So I think a lot of those people, obviously, they still have strong opinions that they're trying to profess, and they feel that what they've asked afterwards is still going to
Right.
affect our opinion. In fact,
Yeah.
well, from the short time I've been here, I think I see more emails after the public hearing is done
Right, it
than
gets
before the
everybody
public hearing
energized.
begins.
Exactly.
I mean, it's still a public record. I mean, this is just a terminology thing. But it's not part of the evidence on which you can base your decision.
That's interesting.
Do you ever have people contact you and ask for, if there are any rules of the road on submitting emails? Does anybody do that, or they just
Mo-
send them to you?
Most of the time, people just take it for granted that I'm to do what I'm told and forward it on, and you know what I mean? Like, so people usually don't ask.
Yeah.
So,
But that may be worth doing when you're closing a public hearing,
Yeah.
is to say, this is your last opportunity to get evidence on the record for us to consider in our deliberations. And if someone says, hey, but I want to say something, or you could even say, material submitted after the state.
How about putting a statement in the written published notice for a public hearing that public comment before the public hearing, including letters and emails and appropriate contacts to staff or board, are acceptable and encouraged, but comments or emails made after the close of the public hearing are made at risk of not being considered and made part of the record. And if you publish that statement, to some effect like that, when people read that in the paper, they're gonna be forewarned, and it may give a little bit of guidance that they're not calling Danielle and asking about.
Yeah, that's a good idea. I would like to help you with the language.
yeah, no,
you add that,
absolutely, yeah.
Isn't it also possible we could say at a public hearing, like, one reason you have a public hearing is information comes out, and people sitting at home are listening. That's why we're doing this, right? And they say, oh, geez, I'd like to make a comment now. So would it be appropriate to have a public hearing that's a lot of activity that we say, public's allowed to make comment for 2 days?
I mean, you would have to, instead of closing the public hearing at the end of
Continue,
that,
yeah.
continue it to the next meeting, and that's perfectly acceptable. I mean, although I will say, unless you have a plan to do that, if
Yeah.
you're sitting at home watching a public hearing, you need to know that, or you are at risk of not being able to get in any of your comments, because you're sitting at home.
Yeah, I get
Public hearing.
emails during the
But
week.
maybe the same thing happens there. At the end of a public hearing, chairman announces to the public that
Yeah,
public input is now over for this applicant.
Yeah, because you're also putting the applicant at risk of not receiving fair due process if you just capriciously continue the public hearing, so somebody around the block who couldn't make it tonight wants to come next month and say something. That's not fair to the applicant.
Right, and, you know, by extension, it's not fair to the applicant to consider comments that are submitted after the public hearing that they don't have a chance to respond to.
Right, right.
Yeah, this is good. Did you have anything else?
No, that's basically my concerns, is just with that and, I
Anything
said I
else?
did have the questions about the site walk thing, well, I just, took it that it said the rule that anything in the station's in the station, anything out is me, so.
Yeah, although it may be worth
Right.
bringing that to the Board of Selectmen's attention, that there are site walks and those don't have, they don't,
Unless we're
Put it
gonna start
to work
investing
there.
in,
Yeah, 'cause I can see
Yeah.
a budgetary thing.
Yeah,
I
exactly.
don't think the whole.
Yeah, exactly.
Anything else you want to touch on, Shannon?
That was all I had for the material. I think we've kept you here long for a workshop.
Now, the items that we brought up tonight now, because our next item was to talk about the bylaws, is that through this conversation, does that pretty much cover that, or the additions that you wanted to make?
We talked about tonight.
I think a lot depends on how you perceive these bylaws, and I,
Does anybody have any comment about
I
the
think they're-
bylaws, anything you see that?
they're guidelines.
Want
I
to
mean,
discuss?
you can say what you want in here, you still gotta deal with the state law. So unless you're gonna put the whole statute in here, or reference it, I think you overcook it. I think what's here is fine. I mean, you could change a paragraph or change a couple sentences, but nothing in there is, it's pretty much procedural, and then it gets in the law side of it, but I don't,
Let's poll the board about, earlier I asked Shauna if she would consider drafting a statement that state statutes, over-govern the language in the bylaws, although then she said the common law sometimes overjudges state statutes. So is there a feeling in the board that we even need to have that, any kind of a statement to that effect in the bylaws, or just let it slide and not worry about it?
I don't think so, personally.
Let it go?
I think it's legally sufficient.
I can go either way.
yeah.
I'd let it go.
You're still gonna deal with it either way, so.
Yeah.
We referenced to it, it really has to do with the idea, really it was about conflict and all that, and we already understand that. And we've referenced it, but the state law too, probably not,
Okay.
in my
I
opinion.
do have one question on the bylaws, which,
Sure.
and it goes back to this great case applicant we were dealing with. I was on the board at the beginning of this application process. I left to go to Budget and Finance, then I came back. Okay?
Okay.
Things happened in between. Basically, I agreed to and was told I had to go review. It ended up being two very large boxes of what had occurred in between. New member came on and said, well, I'm not gonna go through it because he wasn't involved, and was told he needed to abstain from that application. That whole issue's not in here.
Yeah,
There's no issue of if you miss
if you miss a meeting.
so many meetings of an application, or, it's, because I was looking at it, it's not really addressed in here. And I don't know if that needs to be addressed.
Yeah, I mean, people have different minds about that kind of stuff. I mean, I'm of a mind where the bylaws, the more you put in there that's restrictive, you may not be accounting for a situation where you would want to vary from that. And then you're going to be in a situation where you have to justify why you varied from the bylaws situation. And, I think if there's ever a question about whether you can participate, you're going to want to talk to staff, and they may want to talk to my office about whether, it's okay for you to just review all the materials and continue to participate, or whether you should abstain. I I'm not sure I would want to prescribe that in the bylaws to, how many meetings and,
Yeah, well, I'm wondering, well, I think I reviewed this a while ago, so I didn't review it in the last couple days. I think, I was reading it the way the bylaws are written, that really staff couldn't require that,
staff couldn't require what?
that I would have to go back and review the documents. That I, as a member of a voting member of the board, I could just go ahead and vote, and so could a new member.
I didn't see any reference in there about that specifically either way.
Right, there isn't, it doesn't, so if you take it, I was reading it that if you're appointed to the board, boom, you can start voting that day.
So I mean, I think where the staff is coming from in advising you to review all the materials is from a perspective of trying to protect the town
Well, I
from
agree
a
with you.
challenge. And so whether it's in here or not, I mean, it kind of goes back to what we were saying before, whether it's in your bylaws or not, there's certain things you're gonna be asked to do because it's gonna best protect the
Okay,
town.
no, I agree with that, I agree,
Yeah.
when I was reading it, I was like, whoa.
But it's
So-
not in there. Well, so is there something in here that you read that made you think that, or just because it wasn't mentioned?
Because it wasn't mentioned, because the situation happened.
Okay.
That's why, it was a unique situation.
I mean, that's happened, actually, that happened to me on my board where I missed a meeting and, they needed me for a quorum for the next meeting, and in that interim time, I got the tape of the meeting and the materials and looked at everything and then stated on the record at the next meeting that I'd done that and I will
Yeah,
participate
yeah.
and,
'Cause on a tangential issue, I think that flows right back to section 9. All decisions must be made on whether the applicant has provided sufficient evidence to prove that all applicable law and ordinance requirements have been met. As a planning board member, you have a duty to make sure
Yeah,
that
you
you
know
have
what's in there.
considered his full application in
Okay.
relation to all of the ordinances and applicable law. And if you can't meet the standard in your own mind of being able to make a judgment based on that, then you have to abstain or
All
recuse.
right.
Or educate
Yeah,
yourself
all right,
accordingly.
all right,
right, yeah. Does that help?
yeah.
I think section 9 does a lot for you.
Okay, I have nothing further. Anybody else from the board? Anybody want to make a motion for adjournment? We have no other business, nothing to table.
I'll
See you
just tell
next
you, I
week.
brought some materials that summarize some of the things we talked about, just for your reference.
Oh, okay.
And, Danielle, there's 2 more copies, because I know one member of the board isn't here tonight. And I can send that to you if you want it separately.
So when that's brought to the selectmen's attention about the DVD, these may get modified anyway.
Right.
Plus you're gonna add that clause from Jim that says that he's gonna bring forward any staff reviews for your review and approval, so that will get added
But we can
eventually
vote
as
on
well.
that.
So, but I'll
Yeah.
wait for the selectmen's decision on that policy.
Probably one of us will have
Might
to
be
go to
helpful
the
for the
selectmen-
future to put
Board
that
of
on the
Selectmen's
planning
meeting
board
and discuss
agenda.
it.
Well, that's a good question, actually.
I was just saying,
Just a review of the standards, in other words, what happened tonight, in other words, we'd wanna know if someone contacted the board of selectmen and what their action is again, about, what do we do about future public hearings?
well, that was what I was just gonna say, about public hearings.
Well, no, not public, I'm sorry, sidewalks.
Yeah, is that probably one of us will have to go to the Board of Selectmen and have a discussion at one of their meetings about what to do about that in order to have to get on their agenda and
Yeah,
Well, staff will take care of all that, anyway.
No, but,
We don't go to any meeting.
I try my best.
Yeah.
Yeah.
but does someone from the planning board have to go?
I'll find out what the
Okay.
what the chairman wants, but
Okay.
if,
Since they have to
cause
serve,
I
I'd
can
be
either
happy to
represent
go,
him,
I don't
or
care.
if someone else wants to come, like, that's, absolutely. I wouldn't stop anyone.
I move we adjourn.
Second?
third.
All in favor? Opposed? We are done.